Now, the much anticipated update coming in for India. The Supreme Court of India has delivered the much anticipated verdict on legislation of same-sex marriage in the country. The top court has refused to legalize queer marriages while saying that they can't amend existing laws and it's for the parliament to enact laws. However, the court took note of the concerns of the queer community and has provided some relief. The Chief Justice of India, while reading the verdict, said that being queer is a natural phenomenon known for ages and is neither urban nor elitist. He said that it would be incorrect to state that marriage is a static and unchanging institution and that it must be ensured that the queer community is not discriminated against. However, due to differences on certain views, the 5-judge bench failed to legalize the status of same-sex marriages in a 3:2 verdict. The court ruled that it cannot strike down the provisions of the Special Marriage Act of India or read words differently. The Act provides for the registration of marriages, which gives legal recognition to the marriage and provides a number of legal benefits and protections to the couple. The petitioners demanded their marriages be recognized under the Act. The Chief Justice said that his court cannot make or amend a law. It can only interpret it and give effect to it. However, the CJI directed the centre government, state government and union territories to take steps to protect queer community rights. These include making sure that queer community is not discriminated against. There is no discrimination for them in access to goods and services, to sensitize public about queer rights. Now, to create a hotline for queer community, create safe houses for queer couple, and also to ensure intersex children are not forced to undergo operations. The Supreme Court bench heard arguments in the case between April and May this year and had then reserved its order. The hearings were held after 21 same-sex couples filed petitions before the court seeking recognition of their relationship with the legal and social status of marriage. The Indian government, as well as some states, had opposed these appeals and had stated that the parliament is the right platform to discuss the matter, which requires a wider debate. Now, during the hearings, petitioners demanded status of spouse in financial, banking and insurance issues, as well as medical and end-of-life decisions, inheritance, succession and even adoption and surrogacy. The petitioners sought recognition under the Special Marriage Act. While the Indian government had argued that marriage is traditionally seen as a bond between a man and a woman, reflecting long-standing religious, cultural and social norms. The government stressed the importance of legal stability and continuity, arguing against any abrupt changes that may trigger societal instability, and highlighted that marriage legislation is a separate issue with broader implications. Now, to discuss this further, we are joined by Bombay High Court advocate Mrinalini Deshmukh. Mrinalini, thank you so much for joining us.
Thank you. Thank you for having me over.
I would like to begin by asking you that the Indian Supreme Court has refused to legalize same-sex marriage in India, and it has stated that it does not have the power to do so and that it is up to the Indian Parliament. While some may argue that it could be passing the buck, how do you view this ruling?
To be very honest, I think we need to understand what the Constitution is. And the Constitution has its own 4 pillars now, of course, which is the judiciary, the executive and the legislation. So obviously making laws is a part of the legislation. The Supreme Court, the highest court, was very, very concerned and very conscious of the fact that they do not want to overreach or overstep what their domain is as per the Constitution of our country. That's point number 1. Point number 2 is that today, but let's look at it in a little positive manner, and I would like to start. It was the same Supreme Court which decriminalized the offence which was under 377 in the IPC with regards to the LGBTQ things. That was the first step that was there. The second step was obviously the community was expecting the Supreme Court to give them the same rights which are available to others who are non-queer and who do not belong to that group. And the Supreme Court has said that we will ensure as a court to ensure that there is safety, there is security, there is no harm done to you. There are certain things that may be granted to you, directions to the police. If you see the Chief Justice's direction, the whole list of which it was given, was also talking about giving rights and suggesting certain do's and don'ts as far as the queer community was concerned. We have to understand that we have come up from a step where they were hiding in the closets to now come out and ask for their rights, and now the courts are recognizing their rights. I think we are not too far off from that stage where we would have same-sex marriages. Speaking for me, I'm absolutely for it, because my queer friend is as much has got a right to lead a life under Article 21 of the Constitution, the way I have a right to lead my life, and in our own way, though our sexual orientations are completely different. Point number one. Point number two that we have to understand is that today, by not legalizing the by not legalizing the marriages of the same sex, what the Supreme Court has said that this is something which is, we direct the center to form a committee, to take opinions, to take something and channelize this into a legislation, probably, but not saying into so many words, to enable them to get the same rights in black and white, as I said, in print, to be able for them to be able to exercise it. Now, even as far as adoptions are concerned, now that was one of the pleas that was taken by the petitioners who were canvassing for the same-sex marriages. The Supreme Court has played a very neutral role by saying that, the adoption, the CARA should consider the queer couples to be adopted, because otherwise there was a big no-no for any queer couples to adopt a child as per the CARA and the JJ, that is the Juvenile Justice Act, was concerned. So I would say it's a small step. We probably the community and people like me who believe in the same-sex marriages would have preferred the Supreme Court giving directions to the union to form a law appropriate, considering everything together. Probably they have not done that. That's where a little bit of despair is there. But I do see some light at the end of the tunnel. And we've made some steps with considering our country, our values, our societal norms, and some of these people who really come from a little archaic background. I think it's a small step, but towards a larger goal.
Sure, like you did mention that you do see light at the end of the tunnel. I would like to touch upon something that you mentioned, where you called it a neutral stand. I have a question to follow up on that. They have been given the right to adopt, the right to choose partners, but legalizing same-sex marriage is ruled out unanimously. I mean, I have a question, and the question is that, is this a nuanced stand or a regressive move for the LGBTQ movement in India?
So I think one of the judgments, and I'm not too sure which was there, that right to marriage is not a fundamental right. If you go to see in the Constitution, it is a customary thing. I mean, there's no law which says that you can marry. But if you want to get married, there are certain do's and don'ts in terms of your age, in terms of what other requirements are as far as a valid marriage is concerned. So if right to marriage is not a fundamental right, so to grant the queer couple the same sex because of the issues which arise would be something very difficult for the Supreme Court to do. But when they said that the right to marriage is not a fundamental right, right to life under Article 21 is a fundamental right, whether you are a queer or group or you belong to any other group. So in that, they have given some progressive steps with regards to adoption, with regards to, they want to have these, making somebody the nominee, having partners in terms of the bank accounts and other contractual obligations which are, or situations which are there. So I think they have tried to find a midway where they cannot overstep or overreach what their role is in the Constitution, but at the same time recognizing there is a great need and great urgency to give this community all its rights, all its recognition, everything that is required, because they have suffered a lot. They have suffered a lot. And all the judges have unanimously said it is not an urban elitist concept as the center was trying to put it. That was a completely wrong way of putting it. You don't have to be rich, you don't have to be educated, you don't have to be literate to be able to accept a person's sexual orientation has nothing to do with his financial or his educational qualifications. So that is something which the Supreme Court has said it in a very vehement manner, giving I think I would say a rather stern call to the center that please do not look at it from that point of view.
Sure.
So I think they had tried to strike a balance. That's how I could put it best.
Sure. Your view is that they have tried to strike a balance, a small step towards, but still there is a long way to go before we see the light at the end of the tunnel.
Yes.
Thank you.
Yes,
Thank
but
you.
I think we'll be able to achieve that goal, and I'm with the community for all their rights.
Sure.
Absolutely.
Let's hope so. Thank you, Mrinalini. Thank you for joining us and taking your time out.